If you're over 18, you should have an estate plan in place, a will, power of attorney, and more, yet the majority of us don't. This legal planning is even more important when Alzheimer's disease and other forms of dementia come into play. Getting legal ducks in a row can mean the difference between financial health and ruin. Sound advice from a legal expert can help ensure you get it right. That's all up next on Still Time for Joy, where we share practical advice for weathering life's storms and inspiring stories of resilience. Hello, I'm Sandra Levine, host of Still Time for Joy. My guest today is Fiona Van Dyck, an elder law attorney whose law firm helps people navigate complex elder law issues with a specialty in dementia planning. Welcome to the show, Fiona.
Thanks, Sandy. I'm very, very happy to be here to talk with you today.
I understand your father had dementia and you were his caregiver, and that in part is what led you to a career in elder law. Tell me about that and what were some of the challenges you faced helping your father with dementia?
Yes, my father was diagnosed with dementia, let's say it was around 2008. And prior to that time, I was a very traditional tax-driven, estate tax-driven, inheritance tax-driven estate planning attorney, working with families to make sure they had really great estate plans in place and making sure we were doing what we could to reduce any tax exposure. So there I was doing that. I'll tell you, my sister is actually a nurse. So if you thought there would be two people who would be very able to navigate, a parent's dementia diagnosis, it would be the estate planning attorney and the nurse. And what we found pretty quickly is that even though my sister had the medical expertise and I had the legal expertise, we were really floored with what we didn't know about the journey and really floored about how the legal documents that I had drafted for him, which were great from an estate tax and estate planning perspective, weren't necessarily strong enough for what we needed to help him through this dementia journey that he was on. So my sister and I, the two of us, really became his caregivers and his agents, and were there to help him navigate through that. And there are just so many challenges that families face, even families that have a legal and medical background. Can somebody live at home? There is making sure somebody doesn't drive anymore. There is having which are incredibly difficult conversations to have with people, especially when it's your parent and you know that they're not safe on the road. There's wandering, right? There is housing. Should he be able to use the stove anymore? There are all of these issues that people face as family members get older, but especially when there's a dementia or Alzheimer's diagnosis at hand. And it really was working as a family with my dad and knowing what we didn't know and what we needed to know that I really added on elder law to my practice. Just as a resource, like I've been there, I've done that. We know what the journey looks like, and to help my clients and my clients' families be able to navigate and avoid the pitfalls that that my family experienced firsthand.
What were some of the one or two of the biggest challenges that you faced that you wouldn't have necessarily anticipated?
Okay. Well, I will tell you one of the biggest challenges was actually getting access to my father's money to pay for his care. And the reason being, and this is when we talk about documents, I always say to people, one of the most important estate planning documents that you can have is a financial power of attorney, right? This is the document that allows somebody else to step in and handle the business aspects of your life, write your checks, pay your bills, sign contracts, deal with the financial situation. And my father had 4 brokerage accounts, right, that had money in them. He needed to move to an assisted living, to memory care, and it's very expensive. And I needed to be able to write those checks, and I needed to be able to access those brokerage accounts. And 3 of the 4 financial firms refused to accept the financial power of attorney. They would only accept a power of attorney that was drafted by their legal department. And in one of the cases, they would only accept that power of attorney if it had been signed within 6 months of trying to use it. It's incredible. And they can do that, right? There are banking laws with regard to the power of attorney, say when banks need to accept a power of attorney, but the brokerage houses, not so much. I was lucky in that one of the four brokerage firms reviewed and accepted the power of attorney. Because I'll tell you, Sandy, it was a very well drafted power of attorney, if I must say so myself. And I then used that firm to grab the other accounts and pull them all to that one company. So I was very lucky in that regard, and I was able to do that. But I have seen, after that, other clients just finding the same thing. We had one client attempting to use a power of attorney, and the financial firm would not accept it because it was 2 days past the 6-month mark. We worked that out for them. I've had a client sign a power of attorney, have her son give it to her son, took it to the financial firm that gave me access to my father's accounts that I was able to use. And we've had that financial firm turn around and say, we're not accepting powers of attorney drafted by lawyers anymore. Of course, they didn't tell my client's son that. What they said to him was, there's an issue with the power of attorney. So he called me up irate. I called the company. All I could get from them is, we're not accepting the power of attorney. And I said to them, well, let me know why so that I can step in and correct it. What is the issue? We're not accepting it. Finally, after speaking to them for about 20 minutes, they admitted that they hadn't even reviewed the power of attorney. They simply weren't accepting third-party powers of attorney anymore. And they needed her to sign their power of attorney. And if she didn't have capacity, she wouldn't have been able to do that. I mean, luckily she did, but this is what we're facing, is sometimes working with financial institutions to get access. But I still believe the financial power of attorney is your most important estate planning document. But I will tell you that in the journey, that was one of the biggest issues that we faced, just trying to pay for care.
It's amazing. Somebody with your expertise would struggle with things like this, which just underscores the need to get professional help in these matters. So your office has a very focused practice on helping people with dementia. You have special training, some of your staff. You yourself have undergone specialized training. Just tell me quickly, what is some of the specialized training you and your staff have undergone, and why go to that length in order to help your clients?
Yeah, so while we help all families, we do have what we call a dementia-focused practice. And that really stems from the dealings that I had and having to help my dad through his journey. So I'm a certified dementia practitioner. Every member of my staff here who works with our clients who have dementia, everybody is a certified dementia practitioner, which is specialized training in how do you communicate with somebody with dementia? What do they need from me? How can we best set up our office environment so that people feel relaxed and at ease and they're able to have these difficult conversations? And beyond that, I'm also trained, I'm a certified trainer for other people looking to seek the certified dementia training. So I train others to be certified dementia practitioners. And Sandy, again, a lot of it is communication. So when somebody comes in and they have a dementia diagnosis, sometimes the thought is they can't sign new estate planning documents. It's too late. There's a diagnosis on the table. And that's absolutely not correct, right? So dementia is a continuum. And you have to see where somebody is at that moment. And what we need when we talk to people about their documents and what they want the planning to look like, they need to be able to understand generally what is the planning. Who are their people? Who do they want? And taking that all into consideration, most people are better in the morning. So if somebody has a diagnosis, I want them to be early in the day, maybe my first appointment in the day to meet with them. And also just letting people speak. So somebody with dementia, it's going to take much longer for them to be able to formulate their response. They hear the question, they understand the question. It's going to take them a minute. It can take 90 seconds for somebody to formulate their response. And we're not used to that, right? You and I, we have a conversation. You ask a question, I respond immediately. And for somebody with dementia, there has to be that time to process. And it's so important to be patient, just not even just in my conference room, but generally in dealing with somebody who has a diagnosis. It's give them the grace to give you the answer and be patient and wait. And it's stopping family members from jumping in and answering the question for them. Because their husband or their wife or their parent, they have the information. It's just going to take them a minute to get it out. But this is their plan, and these are their documents, and we need to hear what they want, even if it takes longer. That's fine. Got all day.
This is an amazing, amazing thing you're offering to your clients, because what we're talking about, and my own mother had Alzheimer's, and I helped her along her journey for about 10 years. And boy, it was a difficult journey. So I can relate to a lot of what you've already said. What you're talking about right now is in the dementia world is called meeting people where they are. And yes, it's so true. A lot of times, as soon as somebody realizes somebody has cognitive issues, they just want to take over. They're very dismissive of the person as though they know nothing anymore. And that's not true. They still can participate in many ways in their own care and their own decisions.
Oh, absolutely.
I want to go over all the legal documents that everyone should have. But before I get to that, how do you know where that line is when a person can handle their own affairs and when they're no longer really capable to do so? How do you make that determination?
It's so hard, right? So I know when I'm not going to prepare documents for somebody, when I feel that they don't have capacity to understand really what we're doing. A child brings them in, and this clients can't identify their child, and like, I can't prepare documents. I can't. We're going to need to go a different route,
Sure.
which is potentially a guardianship, which is always hard. I think it's easier for me to know when I don't think somebody can prepare documents than it is for a child to think about their parent and when do they really need to step in and take control. I think it's easier for me than it is for me as a lawyer than it was for me as a child to know when my dad should not be cooking anymore,
Sure.
should be driving anymore.
Sure. So I do want to go over just a few of the most important legal documents we all should have if you're over the age of 18. And a statistic I read once not too long ago was something along the lines of about, 70% or more of Americans that should have a will don't have a will. But could you just tell me what are, say, 2, 3, 4 of the very most important legal documents you should have in place, all of us?
Yeah. So Sandy, I do documents for 18-year-olds as they go off to college. I'll tell you that. This time of year becomes somewhat busy with working with our students as they go to college. I think of estate planning as having two sides to it, right? So most people come in and they think estate planning, they think it's just the will. But I really divide it into two categories. One, I consider to be your disability documents. Those documents that come into play if you're not gone, but you're not able to manage things for yourself, right? So if you become incapacitated, who's going to step in and make decisions? So that's, as I talked about before, that, the power of the financial power of attorney, the document that says who can step in and handle the business of your life. And I still think that's really potentially your most important estate planning document. The government has a plan for you after you pass on, but there is no plan to allow for other people to step in and handle your finances or make healthcare decisions necessarily for you if you haven't said, right? Maybe on the healthcare side, but on the financial side, A lot of people think if they're married, obviously their spouse has the ability to do that, but neither the government nor the bank thinks that you like your spouse or that you want them to handle those things for you. So that's the document that is going to allow somebody to access the finances, hopefully, as we talked about a little bit before, to write the checks, to sign contracts for you. And one of the things, especially as people get older with that document, and to the extent that people that are listening have those documents, this is something where I would say, if you have a financial power of attorney, please just go have a look at it, make sure it does have a couple of provisions in it. So one, when we think about asset protection, which we always think about when somebody has a diagnosis, if we want to do asset protection, if the person loses capacity to make those plans themselves, that financial power of attorney has to provide very explicitly that the person, the agent, the attorney in fact, which is the agent under this document, that person that you've given that power to has the ability to make gifts in unlimited amounts to potentially step in and protect those assets. Right? So we make gifts typically for a couple of reasons. One is estate taxes. We want to move assets out of the estate. But that's very few and far between. Really what we're looking at is, do we want to protect assets from long-term care costs? And unless the power of attorney says that that can be done, we can't do it. And we have to go to court. And I don't like to go to court. So I want to make sure these documents have that. So we want to make sure the document has that provision, and we want to make sure that the power of attorney allows the agent to establish irrevocable trusts of which the principal, the person who has signed the power of attorney, is not a beneficiary. So if the power of attorney simply says my agent can make gifts, then it is presumed that the gifting is limited to whatever the gift exclusion amount is in a given year, which is $18,000 this year. But if we are doing asset protection, that $18,000 per person is not going to get us very far.
Sure.
And one of the tools that we often like to use to protect those assets is an irrevocable trust. And the document also has to say that your agent can set up an irrevocable trust. So that's on the financial side. And then on the healthcare side, the healthcare power of attorney, or advanced healthcare directive, as I call it, that's the document that says who can make healthcare decisions for you and what's the scope of decisions that they can make. Another document that I like to draft is a standalone HIPAA authorization. So HIPAA is the Health Privacy Act, right? The physicians, the hospitals are not supposed to provide information to anybody who you have not said that they can provide information to about your medical care and your health. So this is a document that says, this is the group of people that you can share my information with. And it might be, in that list can have people on it that aren't decision makers for you, but people that you would want to be able to speak with your physicians. And, so maybe you're married, you want your spouse to be your decision maker, but you have 3 children who are adults. It doesn't mean you don't want your children to be able to receive information. So
Sure.
You would have them on that document also. And I often say to people, if you have a family member or a close friend who's a doctor, that's a great person to put on your HIPAA authorization, because doctors talk differently to each other than they talk to us, right? And they can go doctor to doctor, and then your family member or friend can come back and tell your family, this is what it really means. And then the last document that I like to see drafted is a living will. And that's the document that gives guidance to the person that's making decisions about what you would want. It's really short. The only thing keeping me going are the machines. It's okay to let me go document. And then on the other side, we have a will or a revocable trust that's going to speak to how you want your assets to be transferred. Who do you want to be in charge of your estate? Who do you want your beneficiaries to be? And how do you want those beneficiaries to receive an inheritance from you? That together is an estate plan.
They are a lot of documents.
Yeah.
They are a little bit complicated, but someone with your expertise can make it all come together into a plan that can really help people to have a smoother transition, whether they have lost the ability to make decisions for themselves or if in fact they have passed away. And we spoke earlier about how people think the will is the most important piece of paper, but it's actually, they really need a durable power of attorney.
Yeah.
But for people who die without a will or they die intestate, many people may not realize that that causes a whole lot of problems for the family. What happens when you die intestate?
Well, the government has written an estate plan for us. So I always say to people, you have an estate plan to the extent that it's a will. You have a will. It's just not the will that you probably want. So there are statutes that say if you die without a will, who are your beneficiaries and who is able to serve is at that point your administrator, right? The administrator would be appointed by the court, and there's a roster of who can serve. And it might not be the people that you want to serve that serve. And the people that inherit might not be the people that you want to inherit, or it might not be the way you want them to inherit. A will can be so important in that regard. You don't necessarily want an 18-year-old to receive $1 million
All at
um,
once. All at
all at
once.
once, right? So I had a great client. She came to me from her financial advisor, and her husband had recently died very unexpectedly, leaving quite a good amount of money and two children from a prior marriage who were at the time, I want to say 18 and 21. And the laws of intestacy say who the beneficiaries are. So she was not the only beneficiary. She was the beneficiary together with his sons.
Sure.
And since they were over the age of 18 when they did this, they were receiving a couple of $1 million each at very young ages.
Yeah.
So I, have young adult children, and their frontal cortexes aren't even completely, formed at that point in time. They can't think 2 meals into the future. How are they going to manage $2 million? And he just hadn't thought about putting a will together, or he had thought about it. Many people think about it, but don't act on it for whatever reason. And sometimes I hear people think, if I come in and I do this will, then something will happen to me, as if the fates are protecting you if you don't have a will.
Yeah, that is so interesting to think about, is why people won't go and get their will. They're worried it's going to bring them bad luck or something. But really, once you take care of it, there's actually quite a feeling of relief.
Oh, so we call it peace of mind. We talk about hard topics all the time. We talk about death, we talk about taxes, we talk about incapacity. But, you have to do it with a little bit of humor, right? Or how do you make it through the day? The goal is to talk to people about, what are their big concerns? How can I help them? Realize the plan that they want. And it's all in the documents, and it's being able to draft the document that somebody wants and knowing what they need and offering guidance and advice, right? So we always talk to people about who are their people and who do they want to put into different roles. And then we get a little bit nosy with people, well, tell me more about your son, who you want to be your agent, your attorney in fact, under your power of attorney. And then they tell me that, he's on his second bankruptcy. It's like, maybe he's not the one to put in charge of your checkbook. And then they tell me, well, I'm just going in birth order because his feelings would be hurt if he were not named. And we always talk about looking beyond that, because never give somebody a job that they're not suited for, right?
Sure.
There is a reason I am not an electrical engineer.
Yet everyone in your family is, right?
Everybody in my family is.
Didn't you tell
I
me that
did
you're the
tell you
outlier?
that. I am the outlier. I come from a family of physicists and engineers, and then there's me. Well, I walk around with a 30-year-old calculator at all times. And yes, and I love a good schematic. I will tell you that. So I think it's very helpful when I meet with clients. I like to really map out their plan. And I've got my whiteboard with me at all times, big whiteboard, to draw it out, because most of us are visual. And we start talking about complex, topics and how different people are, especially young people, are going to receive their inheritance and trusts and things like that. So I guess that engineers buried deep inside of me, but with an inability to do higher level math.
So I want to get back to talking about dementia planning. And we
Yeah.
talked about powers of attorney, healthcare directives, wills, all important for everyone over 18. What are some of the unique challenges and some of the things you have to do when dementia is involved that are different or more complex? Or how do you provide extra help for people?
Usually, when we do estate planning documents, we want to update them every so often. I always say estate plans are not meant to be put in a drawer and not brought out and reviewed. I like to look at them with clients every 3 to 5 years. But when we're building an estate plan for somebody with dementia, we're often not going to be able to revisit it. Right? We're not going to be able to come back in 3 years and say, oh, I want to make this change. So we need to build in as much flexibility as we can to be able to potentially make some changes down the road. We want to make sure that we have the right people in the right roles and really, really talk that through and think that this document, we're not going to be able to make a lot of changes to certain aspects of it. And we want to make sure, especially when it comes to if we're building a trust or we're building the financial power of attorney, that we have the provisions in there that if we need to do asset protection, we can do that. Right. And again, I'm talking about asset protection because most people that come to my office after they've received a diagnosis, it is to think about, if I need memory care, how is my family going to afford $10,000 to $12,000 a month for that? And if I need nursing home care, how is my family going to afford $13,000 to $16,000 a month? Because often what we see with dementia is that people can have this disease for an extended period of time and need care. And a lot of times we will have clients come in, their families will come in and say, well, I talked to my financial advisor and he or she said, oh, people only need care for 2 years. And that is absolutely not the case, right? So maybe people go into a skilled nursing facility, very physically frail at that point in time, because a skilled nursing facility is like one step below a hospital. There's skilled nursing care there. But with memory care, it's typically in an assisted living. And people can be in memory care. I've clients that are in memory care for 10 years,
Yeah.
right? And $12,000 a month for 10 years, it's over $1 million. How are we going to pay for that? And many of my clients, they're concerned that everything that they have worked for their entire lives is going to be used to pay for their memory care. So what can we do to limit what gets spent on care so that the money is there for them, right? Protected for them, first of all. And then when they're gone, there's money left to go to their families, if that's their goal.
So we're talking about like a Medicaid spend down. Can you summarize in a couple? It's a complicated topic,
It
but
is a complicated topic. So, I would always say when people want to do this type of planning or they're thinking about it, they really need to go to somebody that does this, right? Not the attorney that does, a will on Monday and a divorce on Tuesday and they're handling somebody's DUI on Wednesday. It needs to be a firm where there's somebody that really this is what they do. So when we're thinking about this type of planning, we are really thinking, as I said, about asset protection. How do we transfer assets? To whom or to what do we transfer assets? Knowing that there's a 5-year look back. So kind of stepping back from it for a minute, we're really talking about Medicaid planning. So Medicaid is a federal program that's implemented by the states. So every state's program is a little different. What we have in New Jersey is different from what we have in Pennsylvania and incredibly different from what they have in New York. So we need to think in some circumstances, especially where I am in Mercer County, New Jersey, where Pennsylvania is 20 minutes away. Sometimes the conversation is if we need to make a Medicaid application and we need to do planning, are we better off doing it in New Jersey or are we better off doing it in Pennsylvania? So that's one thing. But we're really thinking about within this 5-year look back, do we have 5 years? Can we make transfers at the end of the 5 years? They don't get reported and we can qualify asset wise. Or sometimes do we make transfers knowing that is going to give us a penalty? So it's a time penalty, not a money penalty. It's if we're otherwise qualified for Medicaid and we've made a transfer within 5 years, sometimes our penalty is going to be less than 5 years. So we make a Medicaid application to run that penalty. But in order to qualify for Medicaid, there are 3 requirements. So the first is health. Our applicant needs to require assistance with 3 activities of daily living or have something like a dementia diagnosis. So even though maybe physically they can do those activities, they need to live in a protective environment or they need cueing. The second is income. And the thing to really take away from it is that your income needs to be less than your cost of care, right? So people get confused. And sometimes Google is our friend, and sometimes Google takes us down a rabbit hole we don't need to go down. So just kind of take away that it really is your income less than what your cost of care is. And then the third is assets. So when I'm talking about this gifting and this transferring of assets, that's really where we as attorneys come in and make transfers in order to qualify somebody for Medicaid. Because when we make a Medicaid application for someone in New Jersey, they can have exactly $2,000 or less. And a spouse right now can have a bit over $150,000 with some excluded assets. But it's putting all of that together and coming up with our plan. And I know that's confusing.
Lot to know.
A lot to know. I wish I had my whiteboard.
So not only are you an expert in all these legal matters about elder law, you also are an author and you've written several books. I have one of them here called You're Not Alone. And you've written at least 2 others and have collaborated on a 4th, I believe.
Yeah.
So, and it's so interesting to me that your book is not just about the legal aspects at all. You're talking about communications. You're talking about all kinds of issues with Alzheimer's and dementia. So this is really a passion for you. Tell me a little bit about your passion and how this has affected your whole being, really, having had to help your father that way.
Well, it started with my father and what we as a family went through, and then just hearing more and more stories. And then, Alzheimer's and dementia has in some circumstances been called, type 3 diabetes. There are more and more people that are being diagnosed with dementia and Alzheimer's. And Alzheimer's is just one type of dementia.
Sure.
And more people coming into my office and who have a diagnosis or have a family member with a diagnosis. And I personally, because of what I had experienced, I just want people to avoid the pitfalls. I really just want to have a firm where people can come and feel taken care of and really feel that we have a group here who understands and can really help them along that journey. So I do the legal bit of it, but I have people on my staff here who are fantastic in helping with placement. What are the best places to look at? Because years ago, people would come into my office and they'd have been, they'd recently moved their husband or their spouse in, or their child or has moved a parent into an assisted living or a facility. And I just knew it wasn't the right place for them. And I would ask them, how did you find that location and place? And then they would tell me that often they had used a service and that it was free. Nothing's free, Sandy. Not one thing on this planet is free. And I knew it wasn't the right place, or they had been told that it was going to cost X and it really cost Y, and they weren't necessarily happy, and it wasn't free. So some of the organizations that do assist families with placement, they might not get paid by the family. They're getting paid by the facility.
Of course.
And if the facility, they have a contract with facility A and B, but the best facility for their family member, the long-term care facility is facility C, they're not going to facility C.
Sure.
They're showing A and B. And in my office, I have a fiduciary, I'm a lawyer. I have a fiduciary responsibility to do the right thing and the best thing for my clients. So I have my, elder care navigation team here where we can help our clients find, after talking to them, the best fit for them, knowing that we would never recommend that somebody look at a location that I would not feel comfortable if my mother went there. That's so incredibly important to us that we just work with our families to find, the right placement. And the only people that pay us are our clients. We receive nothing from anybody else. But knowing that when somebody comes, it's not just the legal documents, it's really the whole journey. It's making sure that the placement's right. It's making sure that there's somebody to talk with who can understand and offer suggestions, which is where coming in as, certified dementia practitioners really, we can speak to that. Somebody will come in and talk about their loved one has these different expressions, and it's to help, talk them through why they are doing this, what this means, different ways to help. So we just want to put our arms around our families that we work with.
I know a lot of people wonder about the expense of getting started with preparing all these documents. What would you say to people who are letting the fear of it being expensive keep them from getting started?
Oh my. It becomes more expensive the longer that you wait, in that the more time that we have, the longer our runway is. If we're looking at especially doing asset protection for a family, the longer the runway, the more assets we can protect. The shorter the runway becomes more crisis planning. At the end of the day, people are really faced with two choices. One is that you don't do anything. And every time somebody makes a choice not to do something, they are actually making a choice to do something, right? Inaction is action.
Sure.
And the inaction and the fear of doing something, that action means that your choices become more limited. And if you do nothing at all, and somebody does need care in a long-term care facility, for example, in memory care, you have committed to writing a check every month for as long as care is needed. On the
Sure.
other hand, if you decide to really put what we call a long-term care plan in place, where we look at the assets, we look at the costs, and we develop a plan for how we're going to move forward and how do we protect those assets. You might be spending the legal fees, but you're gaining insight, you're gaining peace of mind, you are ultimately protecting much more than if you had made the choice not to do something.
And can you just tell me what kind of feeling you've gotten from a few clients? Maybe they do have very, very early changes cognitively. They're
Mm-hmm.
still able to act on their own behalf. What kind of feeling do you get from people when they find a firm that is compassionate and patient and understanding? What do you hear from your clients?
It really is the peace of mind that, when people are doing estate planning, just traditional, very tax-driven estate planning, I think that they need to have a team around them. It's the attorney, it's the accountant, it's the financial advisor. When we're doing the long-term care planning for somebody with dementia, they still need their team around them. It's their people. And we want to be part of that team. We want people to know that when they have a question, there's somewhere to come for an answer. When they're facing a particular, expression or behavior, there's somewhere to go to talk that through. And we have our roster of resources that we partner with, that we can provide through them more services to our clients, because uh, there are just other professionals that we know who do a great job, because we only want to work with people that are going to do as good a job for our clients as we're going to do.
Sure.
That we know those people, we can introduce them to those people, and we can help them build that team.
And finally, coming from a family of engineers, I bet you never thought long ago that you would end up having an elder law firm focused on dementia planning.
No,
It sounds like you have found your purpose. Would you say you've found your purpose? And if so, how do you feel about the work that you do?
I love the work that I do. I love the people that work in my office. I love our clients. I'll tell you, I started out years ago when I was a baby lawyer. I was a big firm litigator. I enjoyed some aspects of it, but I made a lot of people cry. I don't like to make people cry. I'm actually a pretty friendly person. And when it got to the point that I didn't care that I made people cry, I knew I had to leave. It was not me. It was absolutely not me. And I saw the trust and estates people down the hall. I'm like, huh, they don't seem to make, people miserable. So, this area of law speaks to me. This area of law, whether it's doing a financial power of attorney, healthcare power of attorney for the 18-year-old off to college, or helping that young couple who just had their first child, make sure that they're protected and they've got their documents in place, but especially dealing with my clients who have dementia or have a family member with dementia, knowing that I can help them along that journey. Love it. It makes me feel proud that I can service them in a way that I know I would want my family to be treated. That's always our goal. I think it makes everybody who works in my office, the way that we want to treat our clients truly, truly is the way that we want to be treated, and that we want our families to be treated. It gives us peace of mind in knowing that we do provide that. We do that.
And in your book, you wrote, I dedicate this book to my father, whose battle with dementia taught me grace in the face of adversity and started me on my journey into the field of elder law.
Yep.
Do you think your dad would be proud of you?
Oh, I think so. Yeah. He was proud of me before, so I'd be extra proud of me now.
Well, Fiona Van Dyck, I want to thank you so much for being on the show today. You gave us wonderful information about estate planning. It's so important. And thank you so much for so generously providing this information.
Thank you, Sandy. It was my absolute pleasure to spend this time with you.
If you found today's show helpful, please share the information with someone who needs it and follow Still Time for Joy for more practical tips on weathering life's storms, as well as inspiring stories of people who have turned their pain into purpose. Please consider supporting the work that goes into producing the show on Patreon. Follow Sandra Levine Productions on Facebook and YouTube, and learn more at sandralevine.com.